All right, welcome back to the Prima.Law podcast. I'm your host, Attorney James Betzold, and today we're diving into a lawsuit that is the result of ICE enforcement actions happening in Chicago, Illinois. Now, we've covered that for the last few weeks, only because it's probably the biggest threat to individual liberty that I've seen in a long time, and it hits pretty close to home here. So the case we're going to be talking about is Chicago Headline Club v. Kristi Noem. It is a high-stakes confrontation unfolding in the Northern District of Illinois. In this case, pits its claims of fundamental First and Fourth Amendment rights against the federal government's asserted authority to maintain order and enforce immigration law and do whatever they want. So this is all taking place in the context of Operation Midway Blitz. We're going to go into some of the filings and some of the happenings in the actual case itself. I know a lot of times when we're watching the news on TV, we might see or listen on the radio, they're just like, yeah, there's a lawsuit. Well, let's dig a little bit into it because there's some interesting things going on. Now, before we get started with that, I want to remind you we are sponsored by Prima.Law. That's Prima.Law, which is legal case management with all the tools an attorney would need, and especially an immigration attorney would need to manage an efficient immigration law firm. Now, this works for law firms. This works for other people who are authorized under law to practice immigration or assist in the filing of immigration applications. And we have over 150 predefined case types. You have billing, invoicing, electronic payments, and a really helpful client portal. And with this client portal, you can use smart interviews and you can use a checklist that your clients will log into, right? In their portal, they'll see the checklist and they can take pictures of the documents that you need. They can upload it securely there and it arrives where it belongs in your case. So you can then use the package assembly tool to put that together neatly and properly and ready for submission. You can either combine that into a PDF or you can submit it via our e-filing tools, which have become more and more popular recently. So find a free 15-day trial at www.prima.law, and let's dig into the topic for today. Okay, so the case today, like I said, that we're going to be talking about is Chicago Headline Club v. Kristi Noem. Of course, Kristi Noem being the head of DHS, which is the Administrative Executive Agency over ICE, CBP, USCIS, all those report to the head of DHS, which in this case is Kristi Noem, or Botox Barbie as they call her. Again, it is high stakes because it deals with very core fundamental constitutional issues that we deal with when it comes to free speech, freedom of religion, freedom of assembly, freedom of press, the ability to protest, and of course, your right to be secure against unlawful searches and seizures. Now, I don't even know where we want to start. There's so much that's happened with this case. I mean, what we've seen in previous episodes that we've covered is literally ICE, and probably CBP was with them, rappelling from helicopters, taking over apartment buildings, busting down all the doors, probably without a warrant because none was ever produced, zip tying children. We see, let's just summarize some of the things we're seeing on social media these days. And these are not AI generated videos, but these are, concerned citizens who are recording, ICE and CBP inside Chicago and the suburbs as they're violating the First and Fourth Amendments to the Constitution, right? So what do we see? We see ICE agents or CBP agents stopping black kids as they're walking home. We're seeing them stop black or Latino kids, Latino gentlemen, Latino ladies, women, as they're literally just walking through a suburb, right? Not doing anything unlawful, not committing any crimes or anything like that. All of a sudden, white dudes in blue jeans, bulletproof vests, and guns are jumping out of unmarked vehicles, rental vehicles, and confronting them, detaining them, grabbing them, literally seizing the person, all without warrant, just because they say, well, this person looks Latino and they're walking in a white neighborhood, or this person is black and they're walking in a white neighborhood. Let's arrest them. Let's go find out what's really going on because now we're suspicious. Well, legally speaking, as we've covered, reasonable suspicion to stop someone or probable cause to say that they've committed a crime has to be something more than how they look. It has to be something more than their race, their religion, their identity, anything like that. You have to have a reason to pull them over. You can't just say, well, we're doing a dragnet of the area. No, those are not lawful. Those are a violation of our civil rights. And if they can do it to a black kid or a Latino woman or a landscaper who's just out working, if they can do it to them, they can do it to you. And they have done it to you, right? When I say you, I'm saying anyone, right? You don't have to be a particular color or gender or anything like that or nationality. The fact that they will go out and do this to anyone is really concerning because, first of all, they don't have to. There's alternative ways for them to investigate and find people who are in the country undocumented, without status, unlawfully present, those sort of things, which are, of course, legal terms of art. But instead, what they're opting for is a shock and awe campaign. And that's not how you act, at least inside the borders of the United States, against your own citizens. So these are the sort of videos that we're still seeing, right? We've seen pastors who are out there literally praying, calling ICE officers to repentance, getting shot in the head with pepper balls. And there's photos out now and documentation showing that one of these gentlemen has like an indentation in his skull now from that. Getting shot with a pepper ball. It's not like they're shooting a poblano or chili pepper at you. No, it is a hard projectile, breaks against your skull. So these are, and we've talked about this, right? When they're using flashbangs, these are grenades, right? They're not throwing projectiles, but they're meant to injure and incapacitate you. And they typically can leave, well, we've covered it, they leave permanent damage as well. All right, so all this we've covered before. Let's actually start digging into it now. The plaintiffs are a coalition, including major Chicago press organizations, individual journalists, peaceful protesters, clergy, and observers. And it paints a disturbing picture. They allege a systematic campaign by federal agents from DHS, ICE, CBP, and other agencies acting under high-level direction to violently suppress dissent and reporting critical of the administration's actions. So when I don't know if I can explain how unconstitutional and how criminal that is. If you have the head of DHS or one of the big cheeses over at DHS and they're saying, we need to take a stand, we need to get violent with these people, we need to do this, that is, you're a bad human being if you're doing that. You're just a bad human being. So that's what they're alleging. That's come out in the complaint. We've reviewed, there's been a couple versions of the complaint now, because what you can do when you file one of these federal lawsuits is you file the complaint. And inevitably what happens is something else will happen like the next day. That's severe enough that it needs to be brought to the court's attention as well. Or maybe there's a witness who comes forward or another plaintiff gets joined to the case and they want to come forward and they have more that needs to be alleged that strengthens the case. So you can file an amended complaint, right? And there's certain rules in federal court for when you can file those, when you can do it without opposition or getting leave from the court to do so. Or maybe there's a change in the law that says, oh, you can't get a national injunction anymore. You need to file this as a class action. So you have to refile a complaint requesting class certification, or any other changes in law that might happen. So that happened in this case. Very normal. So in the filing process of this case, there have been a couple of amended complaints. Those things have been filed in order to stay in conformity with the rules of the court. The allegations in the complaint are pretty stark. Federal agents, often unidentified. That's like no badges, no name tags, nothing, right? We don't know. And it could be difficult for someone to know if this is actually a federal agent or if it's a copycat white supremacist Proud Boy out there, just, taking advantage of the opportunity to go play cop and arrest people, right? That's the danger of a cop not wearing a badge, a name tag, or being able or willing to identify themselves, right? But them using tear gas, rubber bullets, pepper balls, flashbangs, and we talked about flashbangs and pepper balls, rubber bullets. It's not Nerf. Okay. These are like hard rubber, like the rubber that's in your tires of your car, that kind of hard rubber, where if it's coming at you at hundreds of feet per second, it's well documented. Rubber bullets will put an eye out. They will cause injury. They're classified as less lethal, but anything coming at you like a bullet is a bad idea. Flashbangs and physical force against peaceful individuals. We need to talk about that as well, because now we are seeing a lot of videos come out, some of them as a result of Freedom of Information Act requests or because of lawsuits, but we're seeing footage now of protesters outside of an ICE facility, following the law, clearly behind the designated line. They're in their area and just getting pile driven by someone who probably had his glory days in his high school football days, right? So you got someone who's just literally getting tackled for standing there as a peaceful protester. That is unlawful. You're justified in many occasions using up to lethal force to defend yourself against that. However, that's not my advice. You got to take it and go to court. Nobody wins outside of court. You're only going to potentially win in court if you're still alive. Okay? So, but the severity of these violations is just, they're playing, I've said it for weeks, they're playing with fire, and someone's going to get hurt in a bad way. All right? Not just at the Central Broadview ICE facility, but spilling into residential Chicago neighborhoods. Journalists, clearly marked, allegedly targeted while reporting. Clergy members, visibly engaged in prayer, reportedly shot at and gassed. Unlawful arrests without probable cause, followed by quick releases, are claimed to be tools of intimidation. There have been some interesting developments in this case. Recently, we heard, and it was ordered, this was Tuesday, October 28th, District Judge Sarah L. Ellis ordered Gregory Bovino, a senior U.S. Border Patrol official, to appear in her courtroom every weekday to report on his agency's immigration enforcement operations in Chicago. Okay, now normally a judge can't even ask this, right? If there is no case before the judge involving these parties, because of the separation of powers, the judges can do what they do and decide cases, and Border Patrol officers can go patrol the border, which I didn't realize that there was such a severe border in Chicago, Illinois, famously the central airport hub of the United States. But apparently, Customs and Border Protection, or Border Patrol, have quite a presence there that they've upped in recent days. So this Gregory Bovino is a commander, I guess is his title, Commander, Border Patrol. And he's in charge of this Operation Midway Blitz. Now, Judge Sarah Ellis is not willy-nilly requiring him to do this. It's not just, now there's a lawsuit, now you have to report. It's the fact that there have been repeated violations of the court orders and the repeated violations of the First and Fourth Amendment rights that American citizens have, right? That all persons inside the United States have. And so because of these severe violations, plaintiffs have to keep coming back saying, hey, judge, they're still doing this, and they're still doing this, and this is urgent. And we all know that the court has its own inherent powers over those who are subject to its jurisdiction or members of a case that is pending in that court. And so you can see state judges from time to time do creative things like, I don't know, if someone's driving in the high occupancy lane with a mannequin in the seat, to stand out on the street corner with a sign that says, I will not be a dummy. Okay? It's a little bit humiliating, a little inconvenient, but it's part of their sentence, right? It's part of what they're ordered to do. So in this case, what we have is Judge Sarah Ellis saying, hey, this Border Patrol commander, Gregory Bovino, is part of the reason that these alleged violations are happening. And I mean, we say alleged just because nobody's gone to jail for it yet. But there's pretty clear video of it, of these intimidation tactics and constitutional violations. So it's something we need to be concerned of. So I'm going to go ahead in this podcast and take the liberty of saying, no, this is actually happening. This is not an AI generated video. This is a legitimate, multiple witnesses. This is happening. So it's an extraordinary order, right? Usually you wouldn't have a federal official have to report daily on this, but because of the severity, that's what was ordered. It found that they have repeatedly violated a temporary restraining order that she had previously put in place. Now, this is not unique to federal court. This is not a judge trying to legislate from the bench. It's a judge enforcing her own order, right? A court order is an order that you have to follow. It's not optional, and there are consequences when you violate a court order. So, for example, if you're involved in a divorce case and the judge says, hey, don't sell the stuff of don't sell marital assets, and you go sell marital assets, you're going to get your hand slapped. Things could happen. The judge could put you in jail. So in this case, instead of putting Gregory Bovino in jail for violating the temporary restraining order, he said, you know what? Report to me every day. You're going to report to me every day because these things are happening. We're seeing video of it. It's showing up all over TikTok. It's showing up all over Facebook. It's showing up all over the social media network. It's showing up on the local news. It's showing up when our pastors are going back or ministers are going back to their congregations with bruises on their body and pepper balls in their head. Okay? So it's not unheard of. And I know that there's a narrative out there, as the Trump administration would like you to believe, as a lot of the what do we call them? I don't even want to. I mean, it's obviously the Trump administration. It's not everybody who voted for Trump thinks this is a great idea. In fact, it's a bad look. It's as bad of a look as when journalists were embedded into military units in Vietnam. For the first time, people saw on TV the horrors of war. And for now, they're seeing the horrors of snatching people off the street without a warrant or any sort of due process. So it's not a great look, and it's not playing out well. And I think this could be one of the issues that sort of, I mean, we talk about the pendulum swinging to the far right, to the far left. Well, it's swung pretty far left, and now it's swinging pretty far right, politically speaking. Maybe this is one of the things that starts it swinging back in the other direction to a little bit more of a sane country that we all want to live in. So here's some key details of the case. We have the case number. I don't know why they don't do this. Media outlets, if you read about this case, they don't share the case number. And as an attorney, it's like the first thing we want to know. Oh, this is a live case. I want to go on Pacer. I want to download some documents. I want to analyze them. I want to read them. I want maybe have AI analyze it for me because it can do it more quickly than I can go through a whole docket. The case number, they never share the case number. This case number is 25-CV-12173. And if you would like, you can go to Pacer. It's online. It's a court reporting service. They'll have all the documents for federal courts, district courts, and appellate courts. And you can follow to know exactly what's happening in the case and not rely on a 2-second snippet from Fox News or CNN. Okay. So that's the case number. It is in the U.S. District Court for the Northern District of Illinois, Eastern Division. The presiding judge is the Honorable Sarah Ellis. And the key figure here is Gregory Bovino, a chief patrol agent with U.S. Customs and Border Protection, who is leading the federal immigration enforcement effort in Chicago dubbed Operation Midway Blitz. The plaintiffs, as we talked about, are a coalition of media organizations, journalists, protesters, clergy members, free speech advocates. Okay. Now, there was that daily reporting order. I have to tell you because I'm recording this now live. Well, for me, it's live. For you're watching it after, but it's Wednesday, November 5th. And there's been an update to that order, right? The 7th Circuit Court of Appeals ruled, right? Because, of course, the Border Protection objected to this, right? Gregory Bovino, Kristi Noem, they all objected to having to report every day to a federal judge in this matter. So they file an appeal with the 7th Circuit Court of Appeals, which is the federal circuit over Illinois and the Chicago area. And that court, they administratively stayed that part of the order. Okay, so there's an administrative stay. It was issued October 29th. It paused the court order requiring Border Patrol Chief Gregory Bovino to appear in court daily at 5:45 p.m. to report on use of force activities. Now, I don't think that fight's over either. I'm sure there's a lot that a creative and intelligent and smart judge can do to enforce her orders, even when the 7th Circuit Court of Appeals says, we're going to limit that just a little bit. Well, we think there might be some separation of powers issues. I don't know that the issue's been fully briefed or fully decided yet, but it is administratively stayed. So I think we can say that is a temporary measure. Meanwhile, the district court also ordered Bovino to provide body camera footage and use of force reports, and he was even ordered to wear a body camera himself because, he goes out there with his guys and they're doing their rowdy boy routine. Okay. But he's not wearing a body cam. Now they have money. They have the funding for this, but they don't give a crap, right? They don't want the body cam because it means accountability. Now, any smart police officer And I know many, and I've been able to go on, you can actually do a ride along with police officers if they're agreeable. And they'll tell you, we like the body cams. It protects us as an officer against untrue reports, right? So if somebody's saying, I used unreasonable force, I know I'm never going to do that, so I can just go to the body camera footage and I can say, look, I did not. And, if there are people out in the community who will file these frivolous reports against police officers because they got a vendetta, right? Maybe a police officer keeps catching them selling coke, or they keep catching them driving drunk, and then they're like, well, this person's targeting me. Okay, body camera footage is a defense against frivolous reports. There's no reason that federal agents in essentially hostile territory, right? If I'm walking down my town and I see a federal agent, my hair stands up a little bit. I'm like my ears will perk up. I'll be like, what's going on? Why are they here? Because as we've covered before, in the United States, we don't have a federal police force that's designed to police us as citizens living in states that are charged under the Constitution and the 10th Amendment with providing the police, right? Any federal police, some say they're unconstitutional altogether. They're at least limited to when there is an interstate issue, right? Somebody's trafficking someone across a state line or committing fraud across state lines or whatever across state lines. So there's multiple jurisdictions involved, and then there's a federal statute that comes into play. But if I'm seeing any sort of federal police officers, that could be ICE, it could be DHS special agent, it could be even, someone in an FBI vest. If you see them walking around town, it instinctively feels wrong, and that's why. Because in the United States of America, they shouldn't be there. That shouldn't happen. Right now, they have an important function somewhere, but it's not in small town USA. It's not in Chicago, USA. Maybe it's at the airport if you're Border Patrol and you're doing your job there, right? To make sure that as a port of entry to the United States, people aren't getting in who shouldn't. But in this sort of environment where you're going out and you're hated literally by everyone you see, like you never see one of these positive videos where it's like, hey man, thanks for coming out and enforcing the laws on us, and thanks for grabbing up my neighbor, and now I'm going to have to watch their kids forever, right? Nobody's happy about that. Why wouldn't you want to wear a body cam? I mean, I'll tell you why. Because instead of following the law, you're ramming people with your cars, then yanking them out of cars, unlawfully arresting and detaining people, damaging property, causing physical injury. That's why. Well, he's been ordered to wear a body cam. We'll see if he actually does. ICE agents, DHS agents have been ordered to wear body cams as well, especially in response to the allegations in this complaint. All right. Instead of going over, specific areas where we know that things have happened, because those videos are all over the place right now. If you put into TikTok, you want to see Chicago Operation Midway Blitz, you're going to get nonstop footage of that going on. There was a hearing coming up. Yeah, we know about that. We know about that. Okay. All right. So we talked about PACER. We talked about getting the legal documents that we want in order to review the case. And here's this. All right. So let's go over some of the things in the complaint itself. All right. So there are many violations of the Constitution alleged. They allege a pattern of unlawful conduct by federal agents from DHS, ICE, CBP, ATF. ATF is alcohol, tobacco, and firearms, all things that are legal. BOP, FBI, and FPS. Some of those, I'm going to have to look those up. Acting under direction of high-level officials, including the President, DHS Secretary Noem, Attorney General Bondi, and Deputy Chief of Staff Stephen Heil Hitler Miller. Key allegations include suppression of speech and assembly. Federal agents used excessive force, tear gas, pepper balls, rubber bullets, flashbangs, and physical violence to disperse, intimidate, and silence peaceful protesters exercising their rights in traditional public forums like streets and sidewalks. And we all know this I'm surprised how much legal education is out there on TikTok and YouTube and these short videos, right? But if you're on a public sidewalk, that is a public place. You can stand there, you can video record from there, you can talk there, you can protest there, do whatever you want, right? So if you have a house somewhere and there's a public sidewalk in front of you, you're probably aware of that. Particularly outside the Broadview ICE facility, but also in neighborhoods like Logan Square, Brighton Park, Eastside, and Albany Park. Another allegation that they were targeting the press. Agents specifically targeted clearly identifiable journalists with violence, being shot with projectiles, gassed, right? We've seen the videos of that where there is I don't remember her name, a female protester, female journalist out there, right, in front of a camera with a microphone pointing at them, and she's getting pegged with rubber bullets or pepper balls, right? An unlawful arrest like plaintiff, right, held to prevent or retaliate against reporting on federal actions and protests. They allege viewpoint discrimination by allowing favored media access while attacking others. Okay? So under First Amendment violations, we also have retaliation. The use of force and arrests are alleged to be direct retaliation against individuals for criticizing federal policies and actions motivated by hostility toward dissent and specific viewpoints, which you cannot do. If you're going to enforce something against someone or behave as a government agency against someone, it has to be in a politically viewpoint neutral manner. You can't just say, oh, you hate the president? We're not going to give you an interview. Oh, you love the president? We're going to give you access to an interview. Oh, you hate the president? We're going to shoot you in the legs with rubber bullets or in the head or in the chest. Oh, you love the president? You're wearing a MAGA hat? Yeah, we're not going to bother you at all. In fact, we're going to make you a special spot over here. You stay there. We'll be sure not to shoot at you. Okay, you can't do that because these things have a chilling effect on free speech. You cannot tell me that under these circumstances, people are not going to be thinking twice and perhaps not participating in free speech because they're going to be thinking, you know what? Do I want to take a rubber bullet to the eyeball? Do I want to take a pepper ball to the head, to the skull? It chills free speech. It chills the actions that you might take in protesting or demonstrating, exercising your First Amendment right. We never want to disincentivize more speech in the United States. Agents allegedly targeted clergy members like Reverend Black, Father Coran, Reverend Dr. Johnson, and Reverend Holcomb, and others engaged in prayer, singing religious songs or ministry, striking them with projectiles and gassing them while they were visibly identifiable as religious practitioners. This substantially burdens their religious exercise, forcing them to choose between their faith practices and their safety. Again, so the question is going to be, as a minister, do I go and call these people who are doing objectively wicked things? Do I go call them to repentance? Do I go preach to them from a public space in an appropriate manner, non-threatening manner, right? Do I do that, or do I swallow my beliefs? Do I swallow my beliefs and hold back on expressing my freedom of speech and freedom of religion because now I'm afraid they're going to shoot me? Okay, so there's also Fourth Amendment violations that were being alleged in the complaints. The force used was excessive. Chemical agents, projectiles, physical tackling and shoving. And not only tackling and shoving, now we can confidently say that there are videos of some of these agents, and this is a law enforcement tactic. You grab someone who's on the other side of the line, you pull them onto your side of the line. Now they've crossed the line. Now they're free game. They're fair game. Right? It's a dirty tactic, but it happens, and there's video of it now as well. So this excessive use of force is excessive and therefore unlawful. It's unreasonable. It's excessive, given that plaintiffs were often peaceful, non-threatening, and not resisting. Right? The indiscriminate nature of crowd weapon deployment is highlighted. There have been unlawful seizures and false arrests, again, under the Fourth Amendment violations. The agents arrested protesters and journalists like plaintiff held, Mr. Blackburn, Mr. Munoz, Alderperson Fuentes. So there's a government official, right, works for the people, elected by the people, literally being arrested without probable cause. That means they're being arrested, placed in handcuffs, and there was no lawful authority for them to make that arrest. What we've seen is ICE officers and CBP officers roaming around Chicago, and someone from a distance might be like, hey, do you guys have a warrant? What are you doing here? And they're like, you're impeding our investigation. You're impeding us. You're impeding us. They obviously don't know what the word impede means, because the people that are getting hired by CBP and ICE are not smart. Not smart at all. And I think that's fair to say from the top to the bottom. From Botox Barbie all the way down to Gregory Bovino, to the dumbasses walking around on Chicago streets in the suburbs now. They're not smart. So someone will tell them, and you can tell that this has happened, right? Probably at their morning briefing, someone said, hey, you know what? Just yell that they're impeding and that you're going to arrest them for impeding if they do anything that you don't like, because that's impeding you from doing what you want to do. And with that same amount of intelligence, that's what you see them doing. Let's go back to the complaint. There are also Administrative Procedure Act violations alleged. Now, I love this. The Administrative Procedure Act is one of those great federal statutes that doesn't get enough attention sometimes. It's under that statute that, as an attorney, I've been able to go to federal court with the help of some other great attorneys. I'm just going to give a shout out here, a quick shout out to Brad Banias. Right, thank you so much for all your help and information and education that you've passed along to me, and all the help in our federal cases as well. But the Administrative Procedure Act says you can't just do something arbitrary and capricious as a government. You can't make people wait forever, for example, for a work permit to be issued. You can't do that and say, oh, well, we don't know. It's going to take 5 years when it shouldn't. Okay. And that's one of the things that we've sued on 10 times now, and won, mostly in the district court, but now at the Sixth Circuit Court of Appeals back in 2022. Barrios Garcia v. DHS. You can go ahead and look that up. That was our case. It's a very good precedent in the Sixth Circuit. But the Administrative Procedure Act governs the procedures that the federal governmental agencies have to act under. So federal agents' actions allegedly violate federal regulations governing the use of force. Example being 8 CFR 287.8, by using more than necessary force, not minimizing harm, and acting outside their lawful authority. That's a violation of the Administrative Procedure Act. So it was included in the complaint. Another allegation, lack of identification. Federal agents often failed to wear visible identification, hindering accountability. And we're not talking about just their name and badge number, but who the hell they are, right? If you're wearing something that says police, that's something, but it doesn't say, like, are you with the county sheriff? Are you with the city police? Are you with the SWAT team? Are you with ICE? Or are you with the Proud Boys, Antifa, or the Northern Michigan Militia? Okay? You don't know who you are. You're just dressed up in military garb, and that's dangerous for reasons that we've pointed out previously. Number 6. It's not number 6 in the complaint, but the 6th topic I want to cover is conspiracy, right? Defendants allegedly conspired to deprive plaintiffs of their constitutional rights. Okay? Now, I know there's going to be some people who are like a little skeptical. Oh, are they really conspiring? Is DHS really, Kristi Noem is really conspiring, right? Like the President Trump and Stephen Heil Hitler Miller, these guys are all conspiring together to ruin people's constitutional rights? Yes, and it's not that difficult to see. It's not that difficult to see because even before or when this was beginning, you heard President Trump say things like, he called Chicago, quote, the most dangerous city in the world, and criticized Governor J.B. Pritzker for letting people be killed in his city because he doesn't want to deal with Chicago. He framed federal actions as a cleanup targeting mostly criminals, but under a tone of punishment of local leadership. You can find that on abcnews.go. He posted a manipulated image with a caption referencing war and deportation, saying, quote, Chicago is about to find out why it's called the Department of War, close quote, which was widely interpreted as a threat and aggressive show of force specifically towards that city. Again, find that on ABC News. Trump urged Illinois residents to band together and demand protection from crime, despite official data showing crime had declined. He also suggested that local officials like Pritzker called him to request federal help in a tone that was seen as coercive. How many more of these do we have to read? Illinois and Chicago leaders opposed the federal intervention, labeling it a federal invasion. Trump escalated by publicly calling for Governor Pritzker and Chicago Mayor Brandon Johnson to be jailed for their opposition to the federal deployment. That's demonstrating, again, a punitive attitude. That's found in Time magazine. Legal memos and court filings describe Trump's actions as driven by a well-documented animus toward Chicago and Illinois, portraying them as targets for federal takeover due to their political opposition to him. Those are part of a broader pattern of hostility and vindictiveness. So when in the complaint they talk about conspiracy against Chicago, the government of Chicago, the leaders of Chicago and Illinois, no, that's well-founded. There's plenty of evidence and there's plenty of statements by the president himself, which are not going to go well in court for him or his agencies, because you can't do that, right? You can't just say, well, you didn't vote for me. Well, let's make an example out of that city. We're going to send federal troops that are now very well-funded, stupid, bumbling idiots, and many times too fat to get a job at the local police department or work for the government in the federal government in any other capacity. We're talking like military dropouts, convicted criminals. These are the sorts of people finding their way into ICE and CBP right now. And we're giving them guns. We're giving them guns? My goodness. So the plaintiffs filed a temporary restraining order on October 6th. After hearings, the court initially granted a temporary restraining order on October 8th. The court later modified the temporary restraining order on October 17th. As modified, that's what placed restrictions on federal agents' actions within the district concerning dispersal orders, use of specific weapons, KIPs, chemical irritants, flashbangs, warnings before force, targeting sensitive body areas, use of force against journalists, observers, and requiring visible identification. That's fresh. That's October 17th. Plaintiffs filed a motion for preliminary injunction on October 22nd, seeking longer-term relief, similar to the TRO. The court scheduled an evidentiary hearing for the motion for November 5th, 2025. So in just today, I guess there's going to be an evidentiary hearing for the preliminary injunction motion scheduled for November 5th, which is today as we're recording this. So we'll be able to give you an update next week on how that went. Defendants, represented by the Department of Justice, have opposed the TRO and preliminary injunction requests, as we would expect, arguing, now these are their arguments. Let's see if we agree with them. The justification for their actions: federal agents' actions were necessary and objectively reasonable responses to violent riots, assaults on officers, citing over 30 officer injuries, use of projectiles and IED found, weapons found on arrestees, destruction of federal property, and obstruction of law enforcement duties at the Broadview facility and elsewhere. They submitted declarations from officials like Russell Hott from ICE and Daniel Parra from CBP and others detailing these alleged threats. Now, we'll take a look at that and we'll see what the judge said about that in a minute. But an IED, come on. Who do you think planted that? Is it more likely that it was a minister from the local Episcopalian church? Or is it more likely that if there actually was an IED, they don't really go into detail what this IED is. Was this like a potato gun? Was this like a Drano bomb where you just put like Drano, and I'm not going to tell you how to do it, but is it something like stupid like that? Is it even real? We don't know because they haven't put up or shut up about it. Weapons found on arrestees. Again, they're saying weapons. A little suspicious instead of saying assault rifles or firearms or things like that, right? Maybe they needed a weapon to protect themselves against the ICE officers that they knew were going to attack them. So that was their response, right? Their response is, no, we need to do this because there's violent things happening. And, we've seen videos of couple protests getting out of hand, right? If you follow the James Betzold rule on protests, right, when you see people gathering together, just walk the other way. It's probably not going to end well. It usually doesn't. Someone's going to get out of control, and then everyone's going to get in trouble, right? Which we're starting to see the government take advantage of, right? So you don't know if that person who threw a rock through the back of one of these ICE vehicles, if he was just an agent provocateur, right? Maybe he was planted there by ICE. Could have been, right? They've done it before. If we're going to believe what we've read or what we know from, how do I say this without sounding too crazy? I don't even want to talk about January 6th because it makes me angry because I just see the video of what happened. But if we're to believe that there are agents placed in pretty much any public gathering, and sometimes they're given the green light to go stir things up, how do we know that's not what's actually happening here? Or if it's just some dummy throwing a rock through a window thinking he's tough, okay? I would be highly suspicious of what's going on there because they know they're in a place where they're not popular. There's been no widespread rebellion against them, right? They can go out and they can do their operations, and they're getting recorded, but they're not getting mowed down by gunfire. Okay. So you have that. Let's see. The defense also says the TRO, so the temporary restraining order and preliminary injunction, is overbroad and unworkable. It's too burdensome, overly broad, vague, unworkable in dynamic and dangerous crowd situations, inconsistent with established law, and improperly micromanages law enforcement decisions. It sounds like the Seventh Circuit may have taken their side on that a little bit. They say it's a violation of Trump v. Casa. They argue that temporary restraining order constitutes an impermissible universal injunction because it grants relief to non-parties, which could be any person, journalists, etc., rather than being limited to the specific plaintiffs, violating the Supreme Court's holding in Casa. And now we see the great flaw with the Supreme Court's holding in Trump v. Casa. Now, I believe we've touched on this case before, but let's just quick refresh our memory on what that is. Trump v. Casa Incorporated is a 2025 U.S. Supreme Court case addressing whether lower courts can issue universal or nationwide injunctions that block enforcement of policies beyond the parties involved in a case. The case arose from district court injunctions blocking President Trump's executive order seeking to end birthright citizenship for children born in the U.S. to immigrant parents. Birthright citizenship in the United States is granted by the Citizenship Clause of the 14th Amendment, which was adopted in 1868, which states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Okay, and forever what that has meant is this part that says, and subject to the jurisdiction thereof, right? Can you get thrown in jail by the United States? Are you subject to the jurisdiction of the United States, right? If you're the child of an ambassador, no, you get the ambassador's privilege. If you're a child of anyone else, yeah, you're subject to the jurisdiction and laws of the United States. You can be thrown in jail by the U.S., and you're born here, okay, you're a U.S. citizen. That was essentially it. And this had to do with the ending of slavery and a bunch of Jim Crow laws they were trying to pass, trying to say that blacks weren't and they didn't have all the same rights and things like that. That was to clear that up as well. But it clarifies, that if you're subject to the jurisdiction of the United States and an ambassador is not, right, and their children are not, but if you're born here, you're a citizen here. Okay, so Trump v. Casa was an effort to overturn that. The Supreme Court, in a 6-3 decision authored by Justice Amy Coney Barrett, held that universal injunctions exceed the equitable authority Congress granted to federal courts. The courts can only grant injunctive relief necessary to provide complete relief to the specific plaintiffs before them, not extend relief to all others not parties in the case. The court emphasized that complete relief for a plaintiff is narrower than universal relief and that broader nationwide injunctions were an overreach of judicial power. Now, here's why the Department of Justice is full of idiots, or at least the ones filing these responses are idiots. Okay, if they're saying, well, this is a violation of Trump v. Casa, Judge Sarah Ellis did not order every Border Patrol officer in the United States or every Border Patrol commander to report to her. It was limited. Gregory Bovino, the cowboy, cow person. We should say cow person. We don't know how he identifies. But he was ordered to report to her, not the whole country. And when he was ordered to wear a body cam, and when he was ordered, hey, if you're going to shoot at people, you got to warn first. You can't just be willy-nilly intimidating people and harassing people and assaulting people who are exercising their First and Fourth Amendments. It was already limited. It wasn't a nationwide injunction. So the allegation that it was a violation of Trump v. Casa? No. What they're saying there is, we think the president gets to order his people to do whatever he wants, wherever he wants, and nobody can say boo about it. That's what they're saying when they say that. And that's highly unconstitutional. And it's also a bad idea. It's also bad public policy. It's like you're trying to start a civil war. Okay? But that's their argument. And, there's lawyers out there. As a lawyer, we know some of them. We've seen them from time to time. Who, when it comes time to file something, they'll just file everything, right? File everything, see what sticks. Even if it's stupid. And that's what we're getting from our government right now. And then what they'll do is they'll go to the press and say, hey, they're not respecting the Supreme Court's order. They're not respecting what you're supposed to. No, it doesn't apply. That's not what's going on here. The defense also argued the geographic scope. They said any relief should be limited not only to the Broadview facility, as most evidence pertains to that location, not the entire Northern District of Illinois, where all these people are operating. They're saying they have some other specific objections to restrictions as well. The journalists and observers. Exempting journalists or observers from dispersal orders is dangerous, they say. They might record you. They might take a video of you doing something stupid. They say it's impractical. It invites abuse with fake credentials. Okay, hold up. No such thing as legit press credentials, by the way. It doesn't exist in the U.S. Constitution. In fact, there was a presidential candidate who came to town a few years ago, and I wanted to get close, wanted to stand, where I could be with the press and get some good photos for one of the local papers. I was volunteering, do some work for them. And so I just printed up my own press badge. It identified the outlet I was helping. It identified me. But there's no such thing as fake credentials because, as we've learned from, again, social media and some people really who are First Amendment professors on social media, you could create, Billy Butt Crack News Network, and all of a sudden you're a member of the press. If you're doing an investigation of your own, if you're gathering information for a story, you may be a private citizen, but now you're also a member of the press because you're performing a press activity. There is no regulation. There's no statute that says you need a press pass issued by the government because then the government's regulating the press, which is forbidden by the First Amendment to the Constitution, right? That was a little bit of genius on the part of the founders. They said, hey, if we're going to regulate the press, well, then the government will control the press. And we don't want that. Okay, so there's First Amendment protections for them. But they're saying, well, it's going to invite abuse. They're going to make fake credentials and requires difficult real-time identification. Well, I'm sure with all their AI, Palantir apps and money, they'll be able to figure something out. But the fact of the matter is, once you're performing a press function, you're a member of the press and you're not regulated in that, right? And as a member of the press, you should be able to observe and report without getting shot at. Because that's what happens even in war zones. We don't shoot at members of the press. Well, never used to anyway. They have objections to the use of force limitations. Of course, they say restrictions on when weapons can be used, example, only against imminent threat, that ignores situations like active resistance or obstruction and conflict with established objective reasonableness standards. Let's be honest, they've not been objectively reasonable when they've been using force. There's enough evidence of that. They object to warnings. The 2 warning requirement is arbitrary, impractical, and chaotic. It's not arbitrary. There's studies on it. There's a reason that in a police academy, they'll teach you about warnings. You're not supposed to just go in guns a-blazing. You should de-escalate. Then you avoid all sorts of problems. Oh, it's too hard for us to give warnings. You sound like a bunch of babies. Identification, requiring names and badges endangers officers due to doxing and targeted violence. Well, then don't be doing stupid things. Maybe get a job where you can be proud of the work that you're doing. Alphanumeric identifiers are sufficient and lawful. They also argue this isn't relevant to the underlying claims. Yes, it is, and it's also a good idea. Of course, the government's opposed to expedited discovery. They've proposed alternative orders. They want to change the language. They've requested a stay. Of course, we know the Seventh Circuit stayed part of the judge's order here. But that's what we're dealing with now. When we're talking about, let's talk more about the First Amendment. There are what's called traditional public forums. Okay, we talked about like public sidewalk, town square, used to be a public market, things like that. So public streets, sidewalks, parks, they have immemorially been held in trust for the use of the public and have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. Government power to limit expressive activity in these forums is sharply circumscribed. Okay, limited. It's sharply limited because these are public places. That comes from a case back in 1983, Perry Education Association v. Perry LOC Educators Association, Perry Local Educators Association, 460 U.S. 37, year 1983. Protected activities include political protest, religious expression, observing, recording government officials, especially police, and news gathering. These are core activities protected by the First Amendment. The right to record police in public is well established by, what's the case? ACLU v. Alvarez. Comes out of the Seventh Circuit, 2012. It's been reaffirmed there. The citation is 679 Federal 3rd, 583. Okay, a restriction on speech based on content, like if the government's going to restrict someone's speech based on what they're going to say, right? Like, I hate the president. If they're going to say that, and we're going to restrict that. You're not allowed to do that. And unfortunately, our president's so dumb that he'll say anytime one of these late night comedians, a TV show host, is critical. Oh, that's illegal. They can't say that about the president. That's calling for violence. No, it's not. It's just that you don't have thick skin enough to have the position you have. Restrictions on content-based speech. Content-based restrictions on speech are presumptively unconstitutional and is subject to strict scrutiny. That comes from the United States Supreme Court in 2015 in a case called Reed v. Town of Gilbert. A more blatant and egregious form of content discrimination occurs when the government targets speech based not just on its subject matter, but on the particular opinion or perspective that is being expressed. This is also subject to strict scrutiny and almost always is unconstitutional. This comes from a 1995 case from the Supreme Court, Rosenberger v. Rector. And again, the plaintiff's argument is that they were engaged in First Amendment protected activity. They've got all sorts of citations for this. We've talked about those allegations now. The defendant's response is, oh, it's too hard. It's too hard to do our job. So this is what we're looking at. And it's not great, but it is playing out. Okay? It's not great that it's happening at all. But I think it's important as we go on through our week, just to reflect on the fact that plaintiffs were able to come together. And even though their rights were clearly violated by the federal government, they were able to gather together as co-plaintiffs in a federal lawsuit to challenge these actions. Now, sometimes we say the wheels of justice move slowly. Sometimes they do. But one of the benefits of bringing a federal case like this and then winning is you get federal precedent, right? More courts in the future will be able to handle these cases more expeditiously because there is written court precedent on it. There's binding precedent on it. And sometimes you have to see the government do really crazy things, and then you have to stand up to those really crazy things in order to get what we would all, at least in the legal profession, say, this is fairly obvious, this shouldn't be happening. But you need an order that says even the stupidest little things, even the simplest things that we've already in many ways agreed upon as a society by having a constitution. So I think there's a silver lining to that. I was really actually impressed by Judge Sarah Ellis's, by her order requiring Gregory Bovino to appear because his people were violating the temporary restraining order. I think it probably would have been inappropriate absent those circumstances. It may end up getting reinstated to some degree, or, maybe she can't require him in person, but as a judge in a federal case, she could still require reports. If not directly from him, then from a subordinate or in form of writing via sworn statement to opposing counsel, because there is that TRO in place. And it gets us to reflect again just on that. I'm just looking at it right here, that Trump v. Casa case. Trump v. Casa, right? Where you can't have a nationwide injunction. And I think that's part of the pendulum swinging very far left and then very far right. A national injunction is a pretty great thing, pretty unique to American society, compared to other countries where you can go into a local district court and say, hey, the federal government is quite obviously violating the Constitution. You should stop them from doing that anywhere until this case is heard and figured out. Makes sense. But when you go to it for, smaller matters, and then you got judges who are approving those things, the pendulum has swung. And it's all about power and who we can trust with power. Now, the founders of the United States were wise in the sense that they took power and divided it up, right? Among states, among 3 branches of government, and even among the Congress between 2 houses. The idea was divide up the power enough where everyone can kind of keep each other in check, and you can avoid the rise of totalitarianism like we talked about last week. But when the pendulum swings, when people abuse it, when they do things, when nationwide injunctions are granted that don't need to be nationwide, you anger a certain demographic of people. And then when they get power, they're going to do it their way, and then they're going to undo that. So it's unfortunate because I think it's very clear in this situation, the court wasn't even writing an order that applied nationwide. But the fact that, the federal government has the audacity to say, oh, we think you're doing that to us, and you shouldn't have the authority to do that at all, and we should be able to do what we want, and we should not be subject to your checks and balances. And I think that's all we need to cover on the case today. I'm sure next week we'll have an update. There's going to be there's going to be a preliminary injunction evidentiary hearing, and we'll see. Maybe the judge is able to issue a stronger order, making some of those things in the TRO permanent. But we'll report back on that. So I want to thank you for joining us today. This case is, again, let me just pull the name up here. I want to get it. I want to say it exactly right. Chicago Headline Club v. Kristi Noem. Right? I'm glad we could review that together, go over what it's talking about, where it is in its process, the different allegations that have been brought, First Amendment, Fourth Amendment, Administrative Procedure Act, conspiracy. All those fun things are included in it. So it's bound to be a very meaningful case. So thank you for joining us with that today. I'll remind you as we close, we're brought to you by Prima.Law, that is immigration case management, legal case management to run your firm. We're talking about invoices. We're talking about billing, collecting electronic payments, gathering documents from clients, storing in a secure location, client portal so your clients can upload documents directly to their checklist, and that data flows nicely into your forms, into your package that needs to be assembled with our package assembly tool. So you can either print that off and file that via mail, or use our amazing e-filing tools that we've built to streamline the process. You can find a free 15-day trial at www.Prima.Law. Again, thank you for joining us today, and we will see you next week. Be sure to like and subscribe.